machine, isn't that right?
Correct. The constant ratio does not account for individual differences in this case.
Now, the red is what would make the machine be wrong, isn't that right?
It's the different ratio of Miss Dawson's individual physiology in this case.
You don't actually believe that Miss Dawson's ratio was lower, do you?
I would not say that, no.
You doubt that it was in fact lower.
No, I would not say that.
You would not say that.
I would not.
So you believe that her ratio was in fact lower.
Yes, 2100 to 1.
That hasn't always been your statement, has it?
Yes, it always has.
Just to be clear, it's always been your statement that her ratio was lower than 2100 to 1.
That is correct.
Your Honor, may I approach the witness?
Yes.
Showing opposing counsel the witness's affidavit. May I approach? That's your affidavit, isn't it, Dr. Norton?
Yes, it is.
That's your signature on the back page?
It is.
Now, when you signed that document, you swore to tell the truth.
I most certainly did so, yes.
The whole truth,
Yes,
and nothing but the truth.
you are correct.
Now, could you please turn with me to page 5? I'd like to start on line 132. Just read silently as I read aloud. Even so, if Dawson's ratio were lower, which I very much doubt, Dawson would be over the legal limit. Did I read that correctly?
That one sentence, however, you need to include the portion before. In this instance, I'm talking about 1100 to 1 as a possible ratio. I'm saying it was not lower than 1100 to 1, but certainly possible to be lower than 2100 to 1.
Dr. Norton, did I read that line correctly, where you said that you
Objection.
very much...
And in regards to Rule 106, the rule of completion, the opposing counsel is taking this single statement out of context. And for that reason, it may falsely prejudice the jury to believe that she does not believe that it's lower than 2100, when in regards, if you read the statement in its entirety, it's about a completely different issue.
Your Honor, the rule of completion does not apply in this case. This is her affidavit. I'm asking her about the statements that she made prior to this trial. Opposing counsel would like to explain on redirect examination. I believe that they're free to do so.
Sustained.
And permission to strike any offending testimony.
So, Dr. Norton, you very much doubt that her ratio was lower than 1100 to 1.
Correct. However, 1100 to 1 itself will lead to a decrease in the blood alcohol content obtained by at least 52%. 0.19 was not likely in this case.
Dr. Norton, that was one of the issues that you had, right?
A huge issue in this case, yes.
The other one was residual mouth alcohol.
Yes, that's certainly possible as an error in this case.
Now, despite those two problems that you had with that test, you still believe that she was drunk, right?
I would say she was drunk. However, that is not indicative of intoxication levels. Everyone's physiology is different. You can be drunk at below 0.08 or above, depending on your individual differences.
Dr. Norton, you believe she was drunk. In your opinion, she was drunk that night.
Based upon my analysis, yes. However, this is not a conclusion as to a blood alcohol content.
Now, not only do you believe that she was drunk, but you believe it is inarguable that she was too drunk to drive.
Objection, improper opinion in regards to the legal conclusion. This goes to a DUI that is inadmissible, pursuant to the previous ruling of the Midlands Supreme Court.
Your Honor, this is the medical doctor that they have brought to talk about her blood alcohol concentration level. They've already talked about the levels of 0.08, and she's already said that she was too drunk to drive and has related that to driving. I am now allowed to ask this question in a medical sense. She's a medical doctor, and she can answer this question in her way. Dr. Norton, in your opinion, it is inarguable that the defendant was too drunk to drive. Isn't that right?
Again, drunk is not a degree of medical certainty. I cannot be sure if Ms. Dawson's blood alcohol content was below 0.08 or above that night, but certainly not 0.19. But I would say she was too drunk to drive.
No further questions.